International Covenant on Civil and Political Rights, General Comment Number 15, The Position of Aliens under the Covenant. 1. Reports from states parties have often failed to take into account that each state party must ensure the rights in the covenant to all individuals within its territory and subject to its jurisdiction, art. 2. Para. 1. In general, the rights set forth in the covenant apply to everyone, irrespective of reciprocity, and irrespective of his or her nationality or statelessness. 2. Thus, the general rule is that each one of the rights of the covenant must be guaranteed without discrimination between citizens and aliens. Aliens receive the benefit of the general requirement of non-discrimination in respect of the rights guaranteed in the covenant, as provided for in Article 2 thereof. This guarantee applies to aliens and citizens alike. Exceptionally, some of the rights recognized in the covenant are expressly applicable only to citizens, art. 25 foot, while Article 13 applies only to aliens. However, the committee's experience in examining reports shows that in a number of countries other rights that aliens should enjoy under the covenant are denied to them or are subject to limitations that cannot always be justified under the covenant. 3. A few constitutions provide for equality of aliens with citizens. Some constitutions adopted more recently carefully distinguish fundamental rights that apply to all and those granted to citizens only, and deal with each in detail. In many states, however, the constitutions are drafted in terms of citizens only when granting relevant rights. Legislation and case law may also play an important part in providing for the rights of aliens. The committee has been informed that in some states fundamental rights, though not guaranteed to aliens by the Constitution or other legislation, will also be extended to them as required by the covenant. In certain cases, however, there has clearly been a failure to implement covenant rights without discrimination in respect of aliens. 4. The committee considers that in their report states parties should give attention to the position of aliens, both under their law and in actual practice. The covenant gives aliens all the protection regarding rights guaranteed therein, and its requirements should be observed by states parties in their legislation and in practice as appropriate. The position of aliens would thus be considerably improved. States parties should ensure that the provisions of the covenant and the rights under it are made known to aliens within their jurisdiction. 5. The covenant does not recognize the right of aliens to enter or reside in the territory of a state party. It is in principle a matter for the state to decide who it will admit to its territory. However, in certain circumstances an alien may enjoy the protection of the covenant even in relation to entry or residence, for example, when considerations of non-discrimination, prohibition of inhuman treatment and respect for family life arise. 6. Consent for entry may be given subject to conditions relating, for example, to movement, residence, and employment. A state may also impose general conditions upon an alien who is in transit. However, once aliens are allowed to enter the territory of a state party, they are entitled to the rights set out in the covenant. 7. Aliens thus have an inherent right to life, protected by law, and may not be arbitrarily deprived of life. They must not be subjected to torture or to cruel, inhuman or degrading treatment or punishment, nor may they be held in slavery or servitude. Aliens have the full right to liberty and security of the person. If lawfully deprived of their liberty, they shall be treated with humanity and with respect for the inherent dignity of their person. Aliens may not be imprisoned for failure to fulfill a contractual obligation. They have the right to liberty of movement and free choice of residence. They shall be free to leave the country. Aliens shall be equal before the courts and tribunals. and shall be entitled to a fair and public hearing by a competent, independent and impartial tribunal established by law and the determination of any criminal charge or of rights and obligations in a suit at law. Aliens shall not be subjected to retrospective penal legislation, and are entitled to recognition before the law. They may not be subjected to arbitrary or unlawful interference with their privacy, family, home or correspondence. They have the right to freedom of thought, conscience and religion, and the right to hold opinions and to express them. Aliens receive the benefit of the right of peaceful assembly and of freedom of association. They may marry when at marriageable age. Their children are entitled to those measures of protection required by their status as minors. In those cases where aliens constitute a minority within the meaning of Article 27, they shall not be denied the right, in community with other members of their group, to enjoy their own culture, to profess and practice their own religion and to use their own language. Aliens are entitled to equal protection by the law. There shall be no discrimination between aliens and citizens in the application of these rights. These rights of aliens may be qualified only by such limitations as may be lawfully imposed under the covenant. 8. Once an alien is lawfully within a territory, his freedom of movement within the territory and his right to leave that territory may only be restricted in accordance with Article 12, Paragraph 3. Differences in treatment in this regard between aliens and nationals, or between different categories of aliens, need to be justified under Article 12, Paragraph 3. Since such restrictions must, inter alia, be consistent with the other rights recognized in the covenant, a state party cannot, by restraining an alien or deporting him to a third country, arbitrarily prevent his return to his own country. Art. 12, para. 4. 9. Many reports have given insufficient information on matters relevant to Article 13. That article is applicable to all procedures aimed at the obligatory departure of an alien, whether described in national law as expulsion or otherwise. If such procedures entail arrest, the safeguards of the covenant relating to deprivation of liberty, arts 9 and 10, may also be applicable. If the arrest is for the particular purpose of extradition, other provisions of national and international law may apply. Normally an alien who is expelled must be allowed to leave for any country that agrees to take him. The particular rights of Article 13 only protect those aliens who are lawfully in the territory of a state party. This means that national law concerning the requirements for entry and stay must be taken into account in determining the scope of that protection, and that illegal entrants and aliens who have stayed longer than the law or their permits allow, in particular, are not covered by its provisions. However, if the legality of an alien's entry or stay is in dispute, any decision on this point leading to his expulsion or deportation ought to be taken in accordance with Article 13. It is for the competent authorities of the state party, in good faith and in the exercise of their powers, to apply and interpret the domestic law, observing, however, such requirements under the covenant as equality before the law, art. 26. 10. Article 13 directly regulates only the procedure and not the substantive grounds for expulsion. However, by allowing only those carried out in pursuance of a decision reached in accordance with law, its purpose is clearly to prevent arbitrary expulsions. On the other hand, it entitles each alien to a decision in his own case and, hence, Article 13 would not be satisfied with laws or decisions providing for collective or mass expulsions. This understanding, in the opinion of the committee, is confirmed by further provisions concerning the right to submit reasons against expulsion and to have the decision reviewed by and to be represented before the competent authority, or someone designated by it. An alien must be given full facilities for pursuing his remedy against expulsion so that this right will, in all the circumstances of his case, be an effective one. The principles of Article 13 relating to appeal against expulsion and the entitlement to review by a competent authority may only be departed from when compelling reasons of national security so require. Discrimination may not be made between different categories of aliens in the application of Article 13.